Every day in the USA, people find themselves in court.
Teak and Stone Partners and the Stevens. All right, matter 39474. We've got the defendants present. Well, defendants slash cross claimants, or counterclaimants rather. And then on Zoom, we've got representing Teak and Stone, John Schroeder and Maya and Argay, right? And Argay.
Yes.
Okay. Sorry if I'm not getting your name exactly correct, ma'am. All right, so folks, we're here for trial now. All right, let me just close out the other cases, bring up this file. All right. So what I've been doing, again, I can't remember if folks were in the courtroom when I began one of the earlier trials here. What I like to do is I start by giving a brief overview of my understanding of the dispute, the timeline, where we're at here. I think that helps test folks frame their testimony so you can see where I'm coming from. As you may have noticed there, these are pretty informal. I like to basically ask a lot of questions. So I think it's helpful for folks to get a sense of where I'm coming from when we begin. So the issue here, generally speaking, because there are cross claims here, but the folks from Teak and Stone Partners LLC are seeking $1,500. That's in excess of a $1,500 security deposit. The security deposit being what the Stevens. Is it the Steffens or the Stevens? The Stevens are requesting in their counterclaim. So at issue here is issues over the security deposit and any charges above that. My review of the timeline is we had a move-in. So the Stevens are former tenants of a home owned by Teak and Stone Partners, and who were landlords. There was a move-in, at least the checklist signed on March 26, 2025, move-out checklist September 7th, 2025, and the security deposit, $1,500. There's also a $200 pet deposit. Upon move-out, Teak and Stone Partners had communicated that due to, looks like primarily two issues, or if not only two issues, they were retaining the full amount of the security deposit and charging an additional $1,500. And those were for essentially carpet replacement to both bedrooms and due to looks like pet related stains in the carpet that required replacement. And then trees had died in the yard, also due to an argument of repeated pet urination. So between the trees, the work related to the trees, and the work related to replacing the carpets, that came to a total charge for Teak and Stone of $3,200. They applied the $1,700 security and pet deposit, bringing it down to $1,500. All right. So that's where my review of the record is. So I will begin then with plaintiffs in the original case then, or the original petitioners rather, representatives from Teak and Stone Partners. You're both on Zoom in separate places. I think we can just do this at the same time though. If you could both come off mute and raise your right hand. All right. Do each of you swear or affirm the testimony you're about to provide today on this matter is the truth and the whole truth?
Yes, Your Honor.
Yes.
Okay. With that, either who wants to speak first may go. When it's my only request here is when people are on Zoom, different locations, just for purposes of the record, be really careful to not try to talk over each other. So it's the record's clear who's speaking. Other than that, go ahead.
Yes, Your Honor. So just give a brief summary here. The tenant signed a move-in checklist confirming the property, including the carpets and trees, were in good condition. During their tenancy, they caused pet-related carpet damage in multiple rooms and allowed two trees to die. A licensed professional confirmed the damage at move-out. We notified the tenants in compliance. applied their security deposit, pet deposit, and the remaining balance owed is $1,500. We have provided 22 exhibits, including a signed lease, a signed move-in checklist, photographic evidence from before and after the tenancy, professional home assessment, notarized affidavit, itemized invoices, and email correspondence, including the tenant's own admission regarding the trees and during our mediation to the pets. We respectfully ask that the court to rule in our favor and award us the $1,500 that is owed, Your Honor.
All right, thank you. And Ms. and RJ Gay, anything you'd like to add?
No, not at this time.
All right, let me see. I'm just checking to see if I have any questions for you before I turn it over.
Oh, excuse me, Your Honor.
Yeah, go ahead.
So I noticed that in your summary, you stated that the trees, that we were going for damages on the trees because of pet urination. Our contractor did state that he believed that was what the cause was. Regardless of the cause of the trees dying, it is in the lease that they are responsible for landscaping maintenance.
Okay. Yeah, so thank you. That actually gets to one of my questions was going to be if that was the sort of the crux of the argument there for the trees. And what I was looking for here as you were providing some testimony was a copy of the lease, because I want to just have that handy. Let's see. Do you bring that up? There it is. All right. If you have it up, if you have if you want to direct me to where in the lease it talks about that, I believe if I recall correctly, it's towards the end.
Yes, Your Honor. So let me get to it. So Exhibit 1 is the signed lease.
29.
Yeah, it's line 29, Your Honor.
29.
Wait, I'm sorry. I think there's multiple lines that say it.
Yes, Your Honor. It's
25.
25, 26, and 28 of the lease.
Okay, of the rules and regulations piece of it.
That is correct, Your Honor.
Okay. Yeah, okay. So let's see. Looking at 24, 25, 26. Yeah, so one question I had here. So on those provisions of the lease, it talks about the HOA taking care of the landscaping, and then that burden falling to the tenants if tenants are notified that the HOA is no longer doing those services, and then they assume those responsibilities. So did that occur?
So the HOA only was responsible for the front yard. The tree damage is in the backyard. So it does state that they're responsible for backyard landscaping and maintenance.
And Your Honor, just to add on that, that is stated in the CCNR, which is provided to them upon move-in. It's a part of their welcome packet for their tenancy.
Right, so okay, thank you. And I'm looking at 25. Let's see, lessee is responsible for the maintenance of the backyard lawn and landscaping. Time of lease, the HOA provides front lawn landscaping maintenance. Okay. If front lawn services are terminated. Okay. All right. So the issues with the HOA are with respect to the front yard. Okay. All right. So if I'm understanding Teak and Stone's argument generally, it's that regardless of the cause, in the lease, there's a responsibility for the tenants to take care of the trees. You had a tree die, and so part of that, it becomes their responsibility.
That is correct, Your Honor.
Yeah. Okay. All right. Anything further from either of you?
No, Your Honor. I believe that our information that we've provided is significant enough to explain the situation.
All right. Thank you. All right. And before I turn it over to the Stevens, make sure I've got everything up. I guess one final question from either of you at Teak and Stone. The photographs of the carpet, I believe I heard reference to, there were uploaded photographs showing before move-in and after move-in. If that is correct, are you able to specify which photographs are before and which are after?
Yes, Your Honor. Just give me one moment.
And if it helps, I do have a list up of exhibits, and I'm looking at, for example, bedroom stain 1 through 4. So I'm looking at those images.
Yeah.
And so if there are other images you'd like me to look at that are before and afters, yeah, I'm happy to look at those, just so I have a sense of which is before and which is after.
Yes, Your Honor. So exhibits 3, 4, 5, and 6 and 7 are the after photos. Yeah, exhibit 2 is their move-in checklist, which states that there was nothing wrong with the landscape on the outside or with the carpets upon move-in. And then exhibits 18 through 22 is the before photos, Your Honor.
All right, thank you both. Okay, over to the Stevens. If you could please raise your right hands. Do you swear from the testimony you're about to provide is the truth and the whole truth? Yeah. Okay. Same goes to the two of you. Both are welcome to testify. If you could please just try to speak one at a time so the record's clear. I don't have any particular questions in front of me. I think the issues here seem relatively clear. There's a argument over whether the pet stains in the carpet required full replacement or if that was normal wear and tear, as well as the same goes for the tree. And so that's the issue we're all circling here. So those are the questions I have in mind around those issues. So I'll kick it off to you and go ahead.
Okay, thank you, Your Honor. I'm Dolores Stevens. My wife Spring and I are the tenants in this case. The security deposit in this case does not belong to Teak and Stone LLC. It is Spring's and my personal property, and it has to be returned to us in full unless they can show that we have caused damage to their property. That is their burden in this case, not ours, and they haven't met it. They have claimed that we killed 2 small trees in the backyard. They have blamed alternately our dogs peeing on the trees or our failure to enroll in their watering service as the reason. Plaintiff submitted an invoice and something they claim is a home inspection on letterhead from a construction company named A&G Construction. From the document we submitted, Exhibit 10, according to the Secretary of State, A&G Construction's sole business purpose is construction. Just that, nothing more. So are they qualified to say why landscaping trees died? We don't know. We know that there aren't any soil samples or any lab tests. These trees could have died for any number of reasons that had nothing to do with us. The soil pH, the wrong amount of sunlight, or disease could have caused these trees to die. No one knows because no tests were done. The home inspection doesn't even identify who conducted the inspection. It could have been anyone. How do we know that the person who did the inspection had any knowledge of horticulture or soil science? We don't.
Can I pause you for one moment?
Yes.
And ask you, so on the tree issue, the folks from Teak and Stone are essentially arguing that you've got, in the legal community, we talk about strict liability, basically means that you're on the hook per the lease for the tree, regardless of whether it's your fault or not, you're responsible for maintenance of the backyard, and whether it's through pet urination or anything else, overwatering, underwatering, that's kind of your responsibility. Do you see the lease the same way, or do you have a different take on it?
I'm not sure because in all honesty, like we were watering everything and then those trees started to die. And there was nothing we were doing with them that we were doing with the rest of the yard and the trees beside them. There's two trees right beside them that were more mature. Our only, like what we concluded was maybe those trees were too young to withstand the summer and maybe planted too shallow, because we were doing the same thing for them that we were doing for everything else in the lawn. And those trees started to die. And I focused on them a little bit more after I realized that. And then I notified Maya that these trees are struggling and I don't know what else to do for them. So I just continued to water them. I even provided them plant food to try to salvage the trees, because they were, every day it was just like the sun was just beating them to death.
Mhm.
And there was nothing that I was doing that was making any change. And I did notify her once I realized, I was like, this is not working. And I don't know if the trees are diseased and they're dying. And I knew that I was responsible for the care of the backyard. And so I was doing everything within my power to keep them alive. And they just were slowly dying regardless of all the efforts.
All right, thank you.
Yeah. Plaintiff has also claimed that our dogs damaged their carpet so badly it had to be replaced after just 5 months of us living in that house. We did have a 6-month lease, but we moved out a month early. We deny that claim too. We took every precaution to avoid any pet accidents, as we knew this was a short-term stay. We had cleaners in every 2 weeks, Exhibit 5. We had rubber inserts in their kennels to keep any pet accidents contained, so the carpet did not get damaged that way. We also put dog gates at the bottom of the stairs and at the bedroom door. We submitted a picture, Exhibit 6, that shows the gate at the bottom of the stairs, so you could see that the dogs can't get through that. And those gates were left up the entire time of our tenancy. So the dogs weren't on the carpet unless they were in the kennels or with us. We did shampoo the carpet immediately on a couple of occasions that one of the dogs had a urine accident, but they never once peed on the carpet or pooped on the carpet. Going back to the plaintiff's home inspection, how do we know that the A&G Construction is qualified to say the carpet had to be replaced because of pet damage? We don't. The home inspection doesn't identify who conducted the inspection. It could have been anyone. But to come to that conclusion, it would take an inspection by someone with expertise in carpet lifespan and how to tell new pet stains from old ones. The plaintiff doesn't have an expert. They have an unsigned piece of paper. Additionally, the carpet was 5 to 6 years old, according to the home inspection, Exhibit 10. And we filed documents showing that the IRS and HUD use a 5-year limit, Exhibit 11A and 11B. Plaintiff would have to show that this carpet still had any value at that age, and they haven't. Even if the carpet still had value, they could only claim a prorated amount, taking into account the entire lifespan of the carpet, not the entire cost of replacing the carpet. And they would have to show that it was our dogs, not someone else's, who caused the damage. They have not. They haven't because they can't. Because plaintiff, Teakenstone LLC's governors, John Schroeder and Maya and Darge, own this house. They only established this LLC the month before they rented to us, Exhibit 8, because they were moving to Hawaii and needed to rent out their home. When I first viewed the house on March 15th of 25, there were moving boxes in the garage, an air mattress and sleeping bag in the downstairs bedroom. A medium-sized metal dog kennel was in the living room. Maya was doing the viewing, and she told me that the people who had been living there had a dog. I can only think now, maybe she was referring to her and her husband and their dog, and how could Teakenstone have rented to any other tenant when it was just established the month before they rented to us? Maya and John have made it to seem like they were just the property managers all this time, not the owners. I found out they were the owners after they filed this case from a property search with Thurston County's auditor's office, which was Exhibit 7, that lists the two of them as the governors of Teakenstone LLC as the owners of the house. So, Your Honor, I think you'll agree that it's more likely that the plaintiff's dog or someone else's dog peed and pooped on the carpet over 5 or 6 years, and that's why the carpet needed to be replaced, than it is to believe that in just 5 months, our dogs, who were properly kenneled and kept out of the carpeted area, except when they were with us, which we immediately shampooed the carpet, and there was a urine accident, caused the otherwise, quote, satisfactory carpet, end quote, according to the move-in and move-out checklist, Exhibit 2 and 3, to have to be replaced. It's not hard to feel like Maya and John saw my wife and I, 2 successful doctors, as an answer to their problem. They needed to replace 2 trees. They needed to replace their carpet. And the home inspection, Exhibit 10, shows that they also needed to repair their roof, which shows they had neglected needed repairs and might not have had the funds to pay for all that. We had 4 dogs. We probably appeared to have so much money that we'd just assume our dogs did it and pay what it cost to replace it. Either way, they did not give us a full and specific statement of the basis for retaining any of the deposit as required by the Residential Landlord Tenant Act, specifically RCW 5918-281A. They gave us an unsigned piece of paper that could have been written by anyone. If you review our email of November 3rd, 2025, it's Exhibit 4, you will see that we originally only received the invoice. It was only after we challenged the lack of supporting documentation that we were given the document the plaintiff claims is a home inspection. You'll also see that we wanted evidence that they never provided to us to back up their claims. Beyond that, you can see from all of our emails that we were thoughtful and attentive tenants the whole time we were there. There is no reason to think that tenants who paid cleaners to come every 2 weeks, as shown in the miracle cleaning invoices we submitted, Exhibit 5. Tenants who plaintiff praised for being such considerate tenants throughout the lease term in their September 15, 25 email, Exhibit 4, would have allowed their dogs to urinate in the house so much that it caused, quote, visible staining that has penetrated through the subfloor and persistent odor consistent with pet urine contamination, end quote, and allow their 1 male dog to urinate so much on 2 little trees in the backyard to kill them in 5 months. Our $500 security deposit is our personal property. Under the Residential Landlord Tenant Act, when the landlord fails to return the deposit, along with a full and specific statement for retaining any portion of the deposit within the time frame required, the landlord is liable to the tenant for the full amount of the deposit. The court can award up to 2 times the amount of the deposit for the intentional refusal of the landlord to give such a statement, and damages for where they are not substantiated cannot be charged to the tenant. Plaintiff has not substantiated any damages, and it's clear that they did not provide us a full and specific statement for keeping our deposit when first only gave us an invoice and then gave us a home inspection with statements only supported by its own conclusions that can't be trusted because it's unsigned and doesn't identify who did the inspection. Giving us that when we had requested substantiation was intentionally refusing to give us a full and specific statement. The landlord tenant is a statute that has to be strictly construed in favor of the tenant. It's that way to protect tenants against unscrupulous landlords who have the upper hand in landlord-tenant disputes. Therefore, Your Honor, we are requesting you deny the plaintiff's claim according order that they return our full deposit and award us $3,000 in damages. And I want to say that we're okay with just the return of the deposit instead of additional funds.
Thank you.
Yes, thank you.
Anything from you, ma'am, or has covered it all? Okay. All right, I have a couple of questions for both sides. I'm just gonna take some notes first before I start asking them. Turning back to folks from Teak and Stone.
Yes, Your Honor.
Let's see. A question that I have for you is, it seems like the basis for much of the, especially the carpet replacement, is based on this assessment from A&G Construction. I would like to know a little bit more about that company, as I mean, it is billed as a construction company, it looks like. What sort of expertise do they have in this type of analysis of carpeting and staining and that sort of thing?
Yes, Your Honor. So A&G Construction has been a company for 15 years, licensed, insured, and bonded. We've utilized A&G Construction during our tenure as a property management company. And with that being said, when they went to go and conduct the move-out inspection, noticing the stains on the carpet, they pulled the carpet back, and that had soaked down to the subfloor, which is also stated on that assessment. Go ahead, Maya.
And Alfredo, the owner of that company, who we work closely with and who did the assessment himself, is a general contractor.
Can you talk a little bit about the move out inspection or the move out checklist from September 7th, I think it was. It marks next to all the line items on floors. They're all marked with an S for satisfactory that I could see. And then, fast forward to the October 3rd email regarding the security deposit being kept. Then there's we need to replace the flooring or the carpeting due to this. Can you talk a little bit about, that's a question in my mind, is how did we get from the move out checklist being satisfactory on all floors to we need to replace them due to the staining? So I'll go ahead.
The move out checklist was performed by the Stevens, Your Honor. So that was their own assessment. And then we sent in our professional to do his own assessment and found that there were discrepancies.
Thank you. All right. Can you talk a little bit about, because so much of this does ride on this home assessment. Can you talk a little bit? You say it's a general contractor, licensed and bonded. I've no doubt that may be the case. But I want to make sure that we're relying on information from someone who has expertise in this particular issue. Just be a licensed and bonded contractor doesn't necessarily mean this is their area of expertise. So has he done this type of work before, looking at carpets, making those types of assessments? Can you talk a little bit more about his background and experience on that front?
Yes, Your Honor. So for the last 15 years that he's been in business, he primarily works in residential areas, conducting move-in, move-out inspections, along with the repairs that need to happen in the homes, along with general contracting attributes that come from that. But he also does work on commercial properties as well. He has quite a large team of employees, Your Honor.
But yes, he has done these inspections in the past, not just for us, Your Honor.
And did the prior tenants or whoever lived in this house prior to the Stevens, were there dogs as part of that? Those tenants as well, or those occupants?
Yes, Your Honor. There were dogs in the property prior to the Stevens taking tenancy, but there were no damages at the time of them at the time of their lease starting.
Okay, so what was the condition? Looking at the move-in checklist, it seems like the carpets were all also listed as satisfactory. So are you saying that at move-in there were no stains at move-in?
So yes, Your Honor. So Exhibit 2 is the signed move-in checklist, which was completed on the 26th of March, 2025, their very first day of their tenancy, signed by both of the Stevens. This document is critical because it confirms in the tenant's own handwriting and signatures that there were no issues with the floors or the trees at the time they took possession. And this establishes a clear baseline condition of the property.
Right. And for the Stevens, do you all agree you did the move-in checklist as well? That was provided. Okay. Thank you. And then for Teak and Stone, is the $700 total for the trim replacement? That's part of the flooring, is that right? The carpet being reinstalled, is that part of that?
That is correct, Your Honor.
All right. Thank you all. I know we've had a lot of testimony here. What I'm going to do is, I guess I've heard from Teak and Stone a lot here, most recently. So I'm going to let you have some concluding remarks on either issue. Again, your request for the $1,500 or why you feel the Stevens are not entitled to the $1,500 back. And then I'll turn it over to the Stevens for their concluding remarks and then make a decision. So go ahead, folks from Teak and Stone.
Yes, Your Honor. To summarize, the tenant signed a move-in checklist confirming the property, including the carpets and trees, was in good condition. During their tenancy, they caused pet-related carpet damage in multiple rooms and allowed 2 trees to die. Licensed professional confirmed this damage at move-out. We notified the tenants in compliance with the law, applied their security deposit, pet deposit, and the remaining balance owed is $1,500. We have provided 22 exhibits, including a signed lease, a signed move-in checklist, photographic evidence from before and after the tenancy, professional home assessment, a notarized affidavit, itemized invoices, and email correspondence, including the tenant's own admission regarding both the trees and the dog's pet stains. We respectfully ask that the court rule in our favor of Teak and Stone Partners LLC and award us the $1,500 owed. Thank you for your time, Your Honor.
Thank you. Over to the Stevens.
So, Your Honor, we understand the responsibilities of being renters. We've rented for many years now, and it's allowed us to move around and explore areas, but we've never had this happen, and we've had these 4 little French Bulldogs for years, and they've traveled with us, and we've rented at multiple places, and we've never had property damage claimed against us. We took every precaution to avoid any of that. As I said, it was a short-term rental. We knew that, and we were very conscientious about how we allowed the animals to be on the property. They had a doggy door. There was no claims about urination on the hardwood floors, which is where they were at most of the time, all of the time, pretty much, except during sleep and when they went into the carpeted areas with us. So we denied the claims that the damage that required replacing the carpet in both bedrooms was the fault of us and our tenancy. And we do request that our deposit be returned to us.
Thank you.
Thank you.
All right. So I'm going to split the claims kind of in 2 here. I'm going to first address the issue with the trees. So on that, and again, what we're looking for here is tenant responsibility for damages that is beyond wear and tear, ordinary wear and tear, or that was sort of agreed to in the lease. Speaking specifically to the trees, there's a provision in the lease stating lessee is responsible for the maintenance of the backyard lawn and landscaping. I'm going to bring that section up here too.
Your Honor, is it possible for me to add one comment?
Sure, go ahead.
So when I reached out to them about the condition of the trees as they were declining, the only response that I got was just keep us informed, keep watering them. There was no advice about steps to take or anything next to do other than just continue to water, which is what I did. This was their property, and I wanted to ask for their advice on what to do about these trees. That there was nothing I could do at that point more than what I had already done, and I received no instructions of what to do with their property.
Right. And on the issue of the tree, I'm finding in favor of the Stevens. Reason being, the provision in the lease explaining that the landscaping and maintenance is the responsibility of the Stevens. I think that can both be true without them being strictly liable for whether or not particular trees make it or not. I think there's a lot of factors that go into that, especially here in this community. And there's evidence in the file that the Stevens were doing their best to take care of that tree or those trees. And some of them appear to not make it. I don't know if That on its own, though, makes them liable strictly for replacement costs of trees that don't make it, to the extent that they were doing maintenance and taking care of the landscaping in the backyard. I think that can both be true, and the trees just simply not make it. I don't think there's enough evidence here to overcome the fact that the Stevens are correct that security deposit is their property unless landlords can make certain showings that they don't get it back. And with respect to the trees, I find that the landlords have not met their burden in this case. I do find the opposite for the carpets, though, and I'm going to explain why. I understand that's really the crux of the issue here. What I'm looking at is, first of all, I want to say I'm not disputing that you did your best, that you had the carpets cleaned, all of that. What I'm looking at, as far as from a legal perspective, is I see a move-in checklist indicating satisfactory floors, and photographs from during the tenancy that do have what appeared to be, pet urine stains and stains of that nature, that would, from a basis of looking at the checklist, looking at the photos, would appear to be new during the tenancy. With respect to the landlord providing the statutorily required notice of the reasonable basis of their keeping part of the deposit to pay for damages beyond wear and tear. The landlord's responsibility here is to reasonably substantiate the charges. I understand you've raised, frankly, genuine concerns about who's this construction company. It's unsigned. There aren't terribly specific requirements in the statute about what it means to reasonably substantiate charges. We do have an invoice. We do have a letter from a contractor, and we do have photographs. I think on balance, and that were provided, and I think on balance, they do show that the landlord has incurred some costs above wear and tear associated with pet stains. So I do think that they have adequately substantiated those charges per the statute. So all that said, given the competing claims, if I can suss them out here, we've got $3,200 that were charged total. Looking at taking out the issues with the tree, my math has that coming down on the Stevens owing $1,000 instead of $1,500, and that basis is the $700 trim replacement for 2 rooms and the $2,000 carpet replacement for two rooms. That comes to $2,700. The Stevens provided a $1,500 security deposit, $200 pet deposit, so they've provided $1,700. Applying that to the carpet and trim costs results in $1,000 remaining balance. I understand that's probably not the result you're looking for this morning. Do you have any questions for me?
In the lease, on line 26, it states that there's a pet cleaning fee that would be applied if there were pet stains that were that needed professional pet cleaning. So I wasn't sure why that wasn't applied instead of a full replacement.
Well, let's see. It looks like Miss Dargay has an answer to that. And while you answered, what line was that?
26.
26 of the
lease.
Of the lease itself.
Yeah, so we would have charged you to have it cleaned if it was cleanable, but for the home assessment, it had penetrated down to the subfloor, which required replacement. So we couldn't just charge you for a cleaning.
And how did they know that if they were just looking at a pet urine stain? And with the age of the carpet already, we are looking at, was it needing to be replaced, and we were a scapegoat for that?
Well, understood your point there. I think based on, one thing that I'm finding is part of the substantiation of the charges is that assessment. You've raised concerns about A&G construction not being qualified. But I think the representatives from Teak and Stone are able to sort of speak to the foundation for this assessment, and it does note that they looked at the subflooring and they pulled it up. So they saw the carpeting. It sounds like they did some further analysis and looked at it underneath as well. So, I don't want to get too much into the specifics at this point. I think they have substantiated that charge based on what's provided here. It sounds like the cleaning fee is not necessarily applicable if they have to do a replacement. And so that's the finding today.
Okay.
And so what I'll do is I'll issue a small claims judgment here. Again, you don't have to wait for anything to come through. Stevens, if you'd like to pay the $1,000 to them now or whenever you may, for Teak and Stone, there'll be a certified copy of the small claims judgment going to your listed address in the amount of the $1,000 plus the filing fee of $50 and maybe you can help me, one of you at Teak and Stone, because the exhibits are tough to read as far as labeling. Do you have any sort of receipt for your certificate of service? I do have the proof of service, but as far as that cost being reflected, not seeing that in the file.
Your Honor, it's not listed on the table of contents. I can look through my email, but I also can understand that because it's not listed in the evidence of us not getting that money back. We understand that, Your Honor.
All right. So we'll find judgment in favor of Teak and Stone for $1,000 principal, $50 filing fee coming to $1,050. Again, a certified copy will be coming to Teak and Stone's listed address, mailed in 30 days. And any questions from folks on Zoom?
No, Your Honor. Thank you for your time.
All right, thank you. And
Thank you, Your Honor.
thank you. From the Stevens, any questions? All right, thank you all for being here. Appreciate your comments and have a good day. Yeah, we can make you a copy of this as well if you'd like. Okay. Thank you all. Have a good rest of your day.
You too.
Your Honor, is there anything further that you need from us, or are we good to exit the call?
You're good to exit the call. Thank you.
Okay, thank you, sir.
4 French bulldogs in the backyard, sun. The trees are dead, but the watering's done. Subfloor soaked in a mystery stain. Who's gonna pay for the carpet paint? You kept the trees, but you lost the floor. A&G Construction knocking at your door. Split the baby right down the line. $1,000 and you'll be fine. Yeah, $1,000 and you'll be fine.